Arizmendi-Medina v. Garland, published by the Ninth on June 7th. And, you know, this is about due process rights of non-citizens. It happened in my backyard in the San Diego Immigration Court. Essentially, you had a pro se asylum seeker who came to court a couple times, and the immigration judge is like, you should have an asylum application filed at your next hearing. And then he hired an attorney just before that hearing, and the attorney showed up, and it seems like this was the first time that the attorney was informed that an asylum application was actually due that day, which is like every attorney's worst nightmare, right?
Yeah.
It's just horrible. And it wasn't even an individual hearing, it looks like. It looks like it was a master, which would make sense. That's when an asylum application would be due. And so then this attorney's there, and she's like, oh my God. And so she immediately asked for a continuance, denied. Then she asks, okay, well, we're at the beginning of the master, I don't know, 9 a.m. I'll come back in 3 hours before you're done with your master, and I'll have this asylum application to file. And the IJ says no.
Yeah.
And then she's like, okay, well, for the last, 8 years, EOIR has permitted window filings of asylum application. You don't even have to file it at a master anymore.
Yeah.
I'll get it to the window today. And I just no. Asylum denied, abandoned, deported. And the Ninth Circuit wasn't having that. And so when this decision came out, I sometimes like to, reach out to the attorneys who won it. And in this case, the attorney, because in this attorney was clear, this attorney had taken it from immigration court all the way up to the Ninth. Quite frankly, this is not what she thought she was getting into, right?
Yes, life.
Obviously. And here she has just been fighting this case. It doesn't, I don't think she did anything wrong, but this is something that would make me nauseous. And she's been dealing with this for years. And I reached out to her, and she had been traveling that day, and she didn't know yet because she'd been traveling. And so it's just incredible, right? The range of emotions then that this decision did for her. I mean, that's the real world thing for the attorneys, much less the non-citizens. But here's some quotes. The Ninth Circuit, quote, no delay at all would have occurred in the adjudication of the merits had the respondent been allowed to submit his relief application to the IJ at any time on that day.
You could do a nominal filing on these things, right? I don't do asylum cases anymore, but you can have a basic, the first 6 pages or something like that. That's all you need.
That's kind of to lodge it for employment authorization purposes, but that's not what this was. You did need a substantively complete application.
Okay.
And doing it in 3 hours before the master is done is not advisable, but you could have.
Yeah.
Quote, a myopic insistence upon expeditiousness will not justify the denial of a meritorious request for delay. It's a great quote. I like the good writing. Filing deadlines are, and also, by the way, the Ninth Circuit didn't think the immigration judge was clear enough about the consequences to the non-citizen of not filing it on this day. But even if the IJ had been to me, give the attorney, the attorney has just been hired. If you believe the attorney that they had no idea, they give them a day. You know what I mean? Maybe it's some of it is that, immigration judges are used to, some of the older ones are used to this framework where you had to file your asylum application at the master calendar hearing, unlike any other application, for reasons that I never understood. But that hasn't been the case for years. You could file this at the window, you could file it online, any other application. Why order somebody deported when they clearly just got an attorney, and that attorney is being quite rude, saying that I'll file it in 2 hours, Judge.
Mm-hmm.
We can still keep the individual that you're setting for 8 months from now. So the Ninth Circuit wasn't having any of that. Very good case for continuances, the denial of relief, being kind to attorneys, all of the above.
How often do you reach out to the attorneys on the cases?
Not that often, actually. I always give the attorney their props, but this one struck me, and I'm glad I did.
Now, I reached out to a couple people. For some reason, most of the time they don't respond. I'm like, oh, you did some great work, congratulations, or something like that, and they don't respond. I was like, that's kind of weird. But Yeah, it's yeah. I always go to read the now that I'm really involved in the field, trying to see who's doing what, who's the game changers are. Pretty frequently enough, the same names pop up a lot.
Yeah, they
There's
do.
getters, yeah.
Ben Winograd and Sang Yup Kim need to start paying me because I promo them so much on my podcast. But that's because they keep winning these awesome decisions.
Yeah.
I only give the props when the non-citizen wins. So, if you're getting your name said, the other problem that's unfortunate is that the fifth and the eighth, I think only those two, but maybe another one. The Fifth and the Eighth Circuit don't say who the attorney is in their day of decisions. So if you win in the Fifth and the Eighth, unless you email me, you never get your props because I'm not going to Westlaw to figure it out.
Well, Kev, thanks again for coming on the show. We'll probably be back in a few weeks to recap a new set of cases from July.
It's gonna be the Fourth Circuit episode
Yeah,
next month.